We're back to give you the legal edge. With the recent and tragic mass shooting at MSU, many are calling on lawmakers to pass new gun laws with the goal of making our communities safer. But the Second Amendment guarantees protections for individuals to have guns. So tonight, attorney Brian Waldman from the Sinus Stramus Law Firm has more on the test the courts use to analyze laws restricting gun rights to determine if they violate the Constitution.
The U.S. Supreme Court has really had two significant Second Amendment cases. The first was a case called Heller, which was the first time that the court recognized or made it clear that the right to possess and bear arms applies to the individual. But in doing so, the court said, we want to make it real clear that like every right, the Second Amendment right to possess and bear arms is not an absolute right. The government has the right to put reasonable restrictions on that right. And so since that time, from 2008 to 2022, courts, when looking at government laws that restrict the right for individuals to have and possess firearms, have said we balance the government's interest in enhancing a safer environment or creating a safer environment for its citizens with the right to bear arms, a very common legal balancing test that balances rights that might be at odds with each other. And then in the summer of 2022, in an opinion written by Justice Thomas, the Supreme Court said, we're going to change that test. In a case called Bruin, they said, the only thing we're going to look at, we're not going to balance rights anymore. We're going to require the government, if they pass a law that restricts an individual's right to possess and bear arms, to establish that that law is consistent with our country's historical tradition of firearm regulation. And so there've been a lot of what people would consider very unanticipated and somewhat upsetting decisions trying to implement that test, which a lot of people, when they read it, thought right away is going to be unworkable. The most controversial and maybe the most recent was a case called Rahimi down in Texas. We have a federal law that I believe is a very popular law. It restricts the ability of someone who's got a domestic violence restraining order from possessing a firearm. Rahimi said, hey, I understand there's a court order, a finding that I am a danger to my ex-girlfriend, but the government still shouldn't be able to restrict my ability to get a firearm. And the Fifth Circuit Court of Appeals said, applying this new test, the government can establish that this law is consistent with our country's tradition of firearm regulation. And therefore, yeah, Rahimi, you've got a constitutional right to possess a firearm, even though there's a court order saying you're a danger to your ex-girlfriend. I think a lot of legal scholars are thinking, hey, Rahimi shows this new test is not practicable, is not workable, and probably something the court's going to have to revisit and go back to something more like the balancing test if we're ever going to find some middle ground.
Well, still to come on 6 News at 5:30. David will be back.